Well, dear Mika, dear Heidi, Timo, thank you very much for inviting me today. It is a pleasure to be in Helsinki with you, and it is a great pleasure and honor for the court to support this event and to jointly work with the Finnish Arbitration Institute for this and for, I hope, future events, many of them, and I'm sure that we'll have a great cooperation in the years to come. I have been asked to say a few words about what the court has done in the past 2 years, almost 2 years since when I took the presidency of the court on the 1st of July of 2015. And I would like to, as a matter of general introduction, recall the words of Sundaresh Menon at the inaugural speech that he made at the 2012 ICA conference in Singapore. And he then described what he defined as being the golden age of arbitration. And he said that the golden age of arbitration was essentially a time when, and I quote him, recognizing that what the business community desires is a fast and ultimately conclusive method for resolving commercial disputes, the courts have gradually eased their supervisory control over arbitration. Now, I will not even try to discuss in the limited time that I have whether the attitude of the court has remained as pro-arbitration and hands-off as it has been in the past. I think there are many signs, at least in certain important jurisdictions, that it is no longer the case, or that it may no longer be the case in the future. But what is certain is that arbitration is not keeping its promise to the business community and to its users to be a simple, fast, and efficient way of resolving disputes. It has become, in many instances, too long, too complex, too burdensome, too costly, and I think that we are at a point when users and the business community is no longer prepared to accept that situation. If we do not put our house in order, businesses will turn their back on arbitration and look at other ways of resolving disputes. The situation that we see is due to many factors, which I cannot, in my limited time, analyze in depth, but we all know them. The arbitration community is still a too narrow and too small community. It is not diverse enough. We do not have enough young arbitrators, enough arbitrators from emerging jurisdictions. The result of this is that users still have to rely on a narrow pool of established arbitrators who end up being, at times, too busy with not enough availability, which of course translates into added costs and delays to the arbitration. There is also the one-size-fits-all culture that we have in arbitration, the widespread use of boilerplate procedural orders number one, which is of course the easy way to go, the habit of applying the same procedure to all cases with very little consideration of the specificities of each case and the origins of the parties, and in arbitration, of course, this pattern of piling up procedural devices of different cultural origins, and the result of this is also added complexity. And finally, we have the so-called due process paranoia, the inability of many arbitrators to deal with issues at an early stage, to front-load their decisions. And the result of this is duplicative submissions, long submissions, lack of focus on the issues, and repetitions. Something has to be done about all this. And I think it is up to arbitral institutions to do their part of that work. The arbitral community at large and institutions such as ICA and the IBA are doing Of course, they are part of the work in terms of education and in terms of promoting best practices, but institutions have a fundamental role to play, and the ICC has, in this regard, taken a number of initiatives, essentially on two planes. The first is what I would call guidance, institutional soft law, and we have, when the ICC rules in 2012 were revised, we have adopted an Appendix 4 to the rules, which was drawn from a report on controlling time and cost in arbitration, which was elaborated by the ICC Arbitration Commission. That Appendix 4 contains useful guidance. It has found its way in terms of references in procedural orders. We have also in 2014 issued a report to in-house counsel and party representatives on the conduct of the arbitration. All this has been very useful, but I think it's fair to say that it has not been decisive in reversing the trend to more time and more cost in arbitration, and there was need for more decisive action at the level of institutional regulation, and this is what we have done essentially with three measures. The first aims at streamlining the initial phases of the arbitration, which I have to acknowledge is too long. I think it is too long in general, but it is too long in ICC arbitrations. This is because we have a system where the parties can nominate their arbitrators, their objections. We have also large complex cases. The average value of our case is $82 million US dollars, even though we have 30% of our workload with cases involving amounts in disputes less than $2 million. So there are objections, there are complexities, and this, of course, adds time because the court is always attent to grant to the parties the proper time to put forward their comments. But still, we need to streamline these initial phases of the proceedings. That is the time from the request for arbitration until when the tribunal is up and running. And in order to do this, we have shortened in the revised version of the ICC Rules of Arbitration that came into force on the 1st of March 2017, from 2 months to 1 month, the time to establish terms of reference. We have also looked at the final stage of the proceedings with a measure that has caused some discussion in the arbitral community, and that is the establishment of a time limit for the submission of awards by arbitral tribunals to the court. As you know, of course, no award, no ICC award can be notified to the parties if it has not been approved as to its form, but also as to its substance by the court. And we have seen in the past some delays. This was not a general trend, but in many instances, tribunals were too slow in submitting their draft awards to the court. In some instances, we saw parties left to wait for a year or a year and a half after the evidentiary hearing before the award hit their desk, and that, of course, was not acceptable. We have established a time limit for the submission of draft awards to the court. That time limit runs as from the last substantive step in the proceedings, and that is either the evidentiary hearing or the post-hearing briefs, not the cost submissions. As from that point in time, a three-member tribunal has 3 months to submit its draft award. A sole arbitrator has 2 months, and there is, in the recent note to parties and arbitral tribunals, a scale of financial sanctions. I know many do not like that word, but I think it's the proper word to use, ranging from 5 to 20% of the tribunal's fees in case of a delay that is not justified by circumstance. Of course, in many instances, delays are justified by special circumstances. There are also delays that are irrelevant, but there are situations in which the delays is due to the lack of availability of the tribunal, the fact that the tribunal did not organize its deliberations sufficiently early, and I think it is good practice to deliberate immediately after the hearing if you can, and in that case we have applied that measure. We have applied it in a flexible way, but we have applied it decisively, and it has been very effective. I can tell you that, of course, when you talk about reductions of your own fees in amount that can go up to 20%, people pay a lot of care, and it has been very effective and very well received. We no longer see those delays that happened to occur in the past. And The third measure, and maybe the most important that we have taken to address the question of time and cost, is the introduction of expedited rules in the last version of the IC rules of arbitration. I will not enter into too many details. I think that there is an event tomorrow to present and launch the expedited rules. Essentially, what should be said about this is that it is a revolutionary system. It is a bold answer to the legitimate expectation of the business community to an arbitration system that goes back to the initial promise of arbitration to be an effective, simple, and cheap way of resolving disputes, in particular for those disputes involving small amounts of money, which are the bread and butter of many small enterprises. The system applies on an opt-out basis. That means that it is mandatory as soon as two conditions are met. The first is that precisely the amount of dispute be less than $2 million, and the second is that the arbitration agreement post-dates the entry into force of the rules on the 1st of March of 2017. If that is the case, of course, we will have opt-ins, and I think we will have lots of opt-ins, but if those two conditions are met, the expedited rules apply mandatory unless there is an agreement by the parties to opt out either in the arbitration agreement or at a later stage. If they apply, the sole arbitrator, because it will be a sole arbitrator, irrespective of any contrary provision in the arbitration agreement, for example, an agreement providing for 3 arbitrators, the sole arbitrator will have ample powers to conduct the arbitration as it sees appropriate to meet the deadlines. And the deadline is 6 months from the case management conference. There will be no terms of reference in expedited rules. And this 6 months time limit is different from the one you see in ordinary rules, in ordinary ICC arbitrations, in the sense that in normal ICC cases, the time limit is extended based on the parties and tribunals' agreement as to the procedural timetable. In expedited rules cases, the timetable will have to be framed in order to accord with the need to have an award within 6 months after the case management conference. There will be extensions, but those extensions will be limited. And granted for limited periods of time based on recent applications. The sole arbitrator will have discretion to decide the case on documents only with no hearing if he or she believes appropriate, and that's a departure, of course, from the ordinary rules. He or she will have the discretion not to allow requests to produce documents, written schedules, not to allow the cross-examination of witnesses and experts, and to take any measure that is appropriate to allow effectively the award to be made in that short time limit. I would like to say a word about 2 other important lines of policy that we have developed. Time and cost is not the only challenge that arbitration is facing. The other one, of course, is that of legitimacy. I will not spend time to discuss what is happening today in the field of ISDS. We have seen the recent European Court of Justice decision on investment, EU investment treaties, essentially killing the prospect of having ISDS in any European Union treaty, because the prospect of having those treaties approved by all national or subnational parliaments with the current climate is, of course, entirely unrealistic. There is a pattern of distrust on arbitration, of criticism coming from part of the public, coming from NGO. Our concern is that this tendency does not spill over to commercial arbitration. We need to do whatever it takes to make sure that arbitration retains the trust of the public and remains a fair and legitimate way of resolving disputes. In this regard, we have worked at the court on 2 lines of policy which I believe are important. I will say a word about each of them briefly. One is transparency and the other one is ethics. On the front of transparency, we have taken essentially 3 measures. When I say transparency, I'm talking about commercial arbitration, so I of course acknowledge the legitimate expectation of the parties for confidentiality. I'm talking of transparency essentially as applied to institutional procedures. We have made our scrutiny process more transparent. If you read the new note to the parties and arbitral tribunals, you will see that parties are now informed of the outcome of the scrutiny process, even if the award is not approved by the court and sent back to a further session. The parties now are aware, which was not the case in the past. In the past, the parties were left to speculate. What happens to my award? We're waiting for the award month and month, and the parties were not aware of the fact that the award may not have been approved, so they were left to call the Secretariat and obtain maybe partial answers. Now the process is transparent. We have made the composition of all ICC tribunals for all cases registered from the 1st of January 2016 transparent. You will find on the court's website the list of all cases with the names of all of the arbitrators, and you see who sits with whom, you see who has been appointed by whom, who is the president, and I think that this is a measure of transparency and accountability that is unprecedented for a commercial arbitral institution. The Milan Chamber of Commerce has adopted the same measure, which I'm very glad, and I think this is a good example of cross-fertilization between institutions. And we have embarked now into an amplified program to provide reasons for the court reasons. We have deleted in the new rules the provision saying that the court shall not provide reasons for its decisions, which was long overdue. We can now provide reasons for the court decision, not only on challenges, but also on our 6-4 jurisdictional decisions made by the court in presence of a jurisdictional objection as to whether the case should proceed with respect to one or more of the claims or one or more of the parties. Also consolidations. These decisions are now open to reasoning as soon as one of the parties requests so. There is no longer the need of an agreement by all parties. And I would like to say a word finally on the question of ethics, because this is for me most important. We have adopted 2 measures which I believe are of extreme importance. One regards disclosures, and the other one regards the conduct of participants in the arbitration. You know that since last year we have included in the ICC note to parties and arbitral tribunals a section on disclosures, which is new for the court, because until then we did not have any, apart what is said in the rules, which is very little. The rules said that you have to disclose, but then say what do you have to disclose and how you make your disclosures. There is now guidance in the note, and this guidance departs to a certain extent from the IBA guidelines on conflicts of interest. Of course, when drafting them, we have drawn inspiration from the IBA guidelines, but they depart from the guidelines in the sense that they do not seek, as the guidelines do, to establish presumptions, to create lists, red, orange, and green. Essentially, there is a very open and ample list of circumstances that arbitrators are directed to consider when preparing their disclosures. The note is premised on a principle which I consider to be fundamental, and it is, to me, the cornerstone of the future of arbitration. It is the cornerstone of trust in arbitration. If trust disappears, arbitration is like financial markets. If trust disappears, arbitration will collapse, and trust is premised on disclosures. If disclosures are not made in a forthcoming and transparent manner, then there are big problems. And some of you may have seen recently a decision of the Brazilian Supreme Court denying recognition to an ICC award, by the way, in a case concerning Abengoa. In that case, there was a failure to disclose by the president of the tribunal. There was a challenge made against the award post-award, and we rejected it because it was post-final award, and our decision was that those challenges should not be entertained once the final award is made. There was a challenge against the award in New York, the seat of the arbitration, rejected, but now we see the Brazilian Supreme Court denying recognition. A disaster for the parties. Millions of dollars, because of course, in that case, if you cannot enforce in Brazil, you cannot enforce the award. The award is just to be thrown in the wastebasket. Millions of dollars in fees thrown away. Years of work, thousands of pages of submissions, just because there was a lack of disclosure on the part of one of the arbitrators. This should not happen, and our policy is and will be extremely strict in making sure that this does not happen. Our guidance, our note is premised on the principle that the parties have a legitimate right to be aware of any circumstance that is relevant in their eyes to decide whether they should object to the confirmation of an arbitrator or mount a challenge. This is their decision. The parties cannot be deprived of that decision. The arbitrator is not the judge of his or her own independence and impartiality. We, the court, are there to cast a judgment on that. And we are also very clear in the note to say that the fact of disclosing, of course, does not imply that you are not impartial, because otherwise you will not accept. It does not entail disqualification, of course, but the fact of not disclosing will be weighted by the court in a strict manner whenever appropriate, and it will be weighted against the arbitrator whenever necessary. So this is a very important piece of guidance. It is an encouragement to arbitrators to be more transparent, more forthcoming in their disclosure of conflicts, and I hope that it produces the desired result. And finally, we have introduced in the, and with this I will finish, in the new note, a new section in the conduct of participants in the arbitration. Participants, not only the arbitrators, of course, but also the parties, their representatives, administrative secretaries, witnesses, experts, all are expected to behave with the highest level of integrity, with honesty, with professionalism. And the note, and that is new also, this is an evolution that is new for the court, the note endorses the IBA guidelines on party representation in international arbitration. It is the first time that the court endorses a piece of soft law that has been elaborated by another institution, and it did not do so because I was the president of the IBA Arbitration Committee at the time when the guidelines were adopted. I pushed a lot for this to be adopted. I know that there has been a debate in the arbitration community. There have been criticism on the guidelines. I believe that the guidelines are an excellent piece of guidance of soft law, and that it is in fact the only practical and meaningful answer to the question of how do you enforce the duty to arbitrate in good faith in international arbitration. And of course, there is a duty to arbitrate in good faith in international arbitration. And by adopting this, we are encouraging parties and arbitral tribunals to draw inspiration from, or when appropriate, adopt the IBA guidelines in the conduct of their arbitration. And again, this is an intent to establish the highest level of ethics in arbitration, because I believe that arbitration will not survive if it does not tackle these two challenges of first returning to be a more effective, cost and time effective way of resolving disputes, and second, to maintain the trust of the users, of the states, of the public as to its legitimacy. And for this, the question of ethics, including the question of disclosures, is of paramount importance. I thank you for your attention, and I wish you a very fruitful day of work. Thank you.